Hi, good afternoon, everyone. My name is Judge Law, and we are going to commence with our Fulton State Expedited calendar. This courtroom tour. Do we have everyone in the courtroom that's required?
My apologies, ma'am. May I have a small request?
Yes, Mr. Segura?
I have a swearing-in ceremony at 3 o'clock. I was told it will only take 5 minutes. Would it be all right if I quickly go off to attend the swearing-in ceremony and then come back after those 5 minutes?
Yeah, that'll be fine. Is it on now?
I know it's at 3.
Okay. Which cases do you have?
I have position 3, 7, 8, 9, 10, and 11.
3, then 7 to 11. Okay.
Pretty much the whole calendar right there.
Okay, all right. Deputy, if we can address position 3 and then 7, 8, 9, 10, and 11, if possible, that'll be great. Thank you. All right, good morning, good afternoon, everyone. This state expedited accusation calendar is a list of cases where individuals have just been booked at the jail and soon after they've been formally accused with the misdemeanor offenses. Yes, we still have a couple more people strolling in.
All right. Second row. Second row. Listen, some people. Come on, listen.
All right, as I was saying, this is a state expedited accusation calendar of criminal misdemeanor cases which have been newly accused by the Fulton County Solicitor General's office. Therefore, this case is now with the state court, and this would be the initial appearance before a judicial officer. My name is Judge Lal, and I am going to be calling each of your cases one by one. When I address your case, please remember that to exercise your right to remain silent. Anything you say about the facts of your case during this recorded virtual proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. And who do we have in courtroom 2?
This is position number 2, Your Honor. No, actually, I'm sorry. Yeah, position number 2, Ms. Rashida Dennis. I'm sorry.
Okay, Ms. Rashida Dennis is case 22 CR 001-249J, originally accused of simple battery and misdemeanor offense. She received a $2,000 signature bond through pretrial services from Judge Morrow on March 8th, and she's back with us. Ms. Dennis, please remember your right to remain silent. Your attorney is going to be Ms. Kim presently. And
it's me, Your Honor. Good
Ms.
afternoon.
McLeod?
It's Marie
Good
McLeod.
All right.
I represent Ms. Dennis.
All right. And who's prosecuting this matter?
I am.
All right, Mr. Segura, position 2 as well. Okay. So, Mr. Segura, why are we revisiting Ms. Dennis?
I'm not sure exactly why we were visiting. We have the exact same charge, which was simple battery. And for the date of offense was March 7th, and the location was at 850 Oak Street, Southwest Atlanta. And our recommendation for this case is a $2,000 surety bond, no further contact with Patrice Anderson. Patrice spelled Patrice, Anderson, common spelling, one-day anger awareness, and alcohol, drugs, and weapons.
Oh, but she's already got a bond. She already received a
That
bond.
is correct, Your Honor.
Yeah.
So she's got she's got a felony case. It was from a 2016 incident. I don't know if it's a bench warrant. So Mr. Segura, you're not aware of that?
I'm not. When I was looking at Odyssey on this case, it just gave us the simple battery again.
Okay, she's got a cruelty felony charge and a battery causing substantial physical harm. This is from March 28, 2016. Ms. McLeod, can you shed some light on this?
Yes, I can, Your Honor. This is an incident my client had when she was a juvenile. She had gotten into an altercation with her mother. It was all resolved. She was sent to juvenile detention and the matter was resolved. For some reason, it doesn't seem to be showing that on the record. So she's just as surprised as everyone else is that this is coming up now, because she was arrested, as the court has noted, and a bond was given to her on an incident where she had an altercation with Patrice, who also lives in the shelter
Okay.
where my client lives.
Let me ask you this, if these were charges arising when she was a juvenile.
Yes, Your Honor.
But were these an SB 440 case eventually?
That I don't know, Your Honor, because she tells me she was 16 at the time. She's now 22.
Understood, but if it's an SB 440, she would have been charged as an adult. So I'm wondering whether one of those charges or any of those charges.
I don't
Okay.
think so, Your Honor. She told me she went to juvenile
All
for
right.
it, and her mother was
Yeah.
arrested as well.
All right, and presently, I don't have the jurisdiction to touch this case at all. Do you have a case number?
I see 16 MAG CO2414.
CO214, that is a.
CO2414, Your Honor.
C as in cat,
Yes, Your Honor.
0214.
Yes, Your Honor.
I don't see that. It could be a warrant application, that there may be not be a complete case number. Oh, DA number. DA. Let's get that number. 22 DA 2270. No, I can't find it. All right, Ms. McLeod, I'm sorry, she's already got a signature bond through the misdemeanor case that's pending in state court, so that's done. The only other issue is this felony charge that apparently has been resolved, but
Yes, Your Honor.
but the case number you gave me appears to be a warrant application number, and it's not complete.
And the person who is given as the reason for the conflict is a Nancy Dennis. My client tells me that is her mother, and that there was an incident when she lived at home with her mom back
I
in
understand
2016.
that. I just don't see the case number. I don't know where. Okay, let me try one other thing and then see if they're trying to walk. And we got EW numbers with the solicitor. Okay. Don't even have any open cases against her. All right. Ms. McLeod, we're gonna have to defer to one of the presiding judges in Superior Court and to inquire as to what is going on. What was the DA number? 22 DA 2272. 2272. Okay. And someone will need to reach out to the DA's office. Ms. McLeod, we probably have to do that and see if this is a juvenile case that should have been disposed of. Right now, we have a reference number 22, D as in Denmark, A as in Apple.
22
Yes.
D.
D as in
I'm
Denmark.
writing.
Yeah.
Yes.
A as in Apple, 2272.
2272.
Correct. And she's going to have to be further notice to the felony court. Is felony court first appearance still going on?
Yes, Your Honor, I believe so.
Okay, can she be taken to the felony first appearance and see if they can research her case? Because she's got a felony charge there, and she shouldn't, and these cases shouldn't be there at all.
I think she was on a pull sheet yesterday.
Do you have a case number on the pull sheet?
I'll be back.
Okay. I'm sorry, Deputy, but that's the best I can do is put her on the felony first appearance that's ongoing and see if they can address any outstanding felony charges she has. Or
And Your Honor, this is Albert Hopkins. I mean, I agree with the assessment. I mean, she was on the pull sheet yesterday for a case that we handled, but it was a misdemeanor case that she was already given a bond on. So last thing I see is just the felony case. She's already
right.
everything misdemeanor.
Ms. Dennis, we are trying to find out what these charges are, and apparently your 2016 matters are still lingering out there to hold you. So we're going to send you to Superior Court first appearance, which is going on at the same time right now, and hopefully the judge will be able to address it. Okay?
Yes, ma'am.
All right. Thank you.
Ms. McLeod, I'll try to see if someone can send you the link to the felony.
Yes, I would appreciate that.
Okay.
Thank you.
Thank you.
Okay. All right. Next case in courtroom 2.
Now we're gonna go to petition number 4, Ms. Gould.
Ms. Corvadis, Rochelle Good. Ms. Good's case is 22 CR 001-292D. Ms. Good is accused of 2 counts of reckless conduct and 1 count of possession of marijuana, less than 1 ounce. Ms. Good, you've been advised of your right to remain silent, and your attorney is Ms. Wanda Gan. Mr. Tucson, any prior? He's already stepped away. From what I understand, all right, I'll let the prosecutor go first. If you have a GCIC as well, you'll take it. Otherwise, we have to wait till Mr. Tucson returns.
Yes, Your Honor.
Please proceed.
The defendant has 3 cycles in Georgia, and they're from 2006 and before. So this would be her first arrest since 2006.
All right. And what's the state's recommendation for the reckless conduct?
Our recommendation, so as to count 1 will be $1,000 surety, count 2 will be $1,000 surety, and count 3 will be $500. So that'll total $2,500 surety bond, a parenting class, and no alcohol, drugs, and weapon. As Your Honor is aware, this was the case where she left her 8-year-old and 1-year-old daughter in the car and left the scene for over 90 minutes. And when she came back, she was arrested, and the officer found 2 blunts with marijuana inside in her possession. So that's going to be the basis of our recommendation, Your Honor.
All right. Ms. Gann?
Thank you, Your Honor. Ms. Kuvadis Good is 38 years old. She has been in the Atlanta area since 2009. She has 4 children, 2 over the age of 18, and of course the minor children ages 8 and 1. She also has parents in this area. Ms. Good completed high school. She also has some college credits in the area of coding and billing. She has been unemployed for the past years. Therefore, she has very limited means to pay bond at this time. Your Honor, her children are in the care of the children's father, Mr. Sapade Morgan, and we are requesting, Your Honor, a signature bond on Ms. Good's behalf, given that she does not have any prior history of allegations. She disputes these allegations. And again, a signature bond. And if Your Honor determines that she is ineligible, then a bond of no more than $1,250, and that would be $500 for each reckless conduct charge and $250 for the possession of marijuana. Thank you.
On each reckless conduct is $2,500, and the possession of marijuana is $500. Total bond is $5,500. Signature bond through pretrial services. First of all, no contact with the children unless there is a defects parenting plan in place. No illegal drugs, no alcoholic beverages, no weapons, and no firearms. She will report to pretrial once a month. She'll be subject to random screens for drugs and alcohol. She will attend and complete a parenting class. Either it's offered by defects or it's offered at a private provider. That's entirely up to her. And this shall be done within the next 90 days at her expense. Once DFACS has evaluated the household situation, they can establish a parenting plan and contact provision. So contact with the two minor children, 8-year-old and the 1-year-old, will be in accordance with the DFACS requirements. Thank you.
Thank you, Your Honor.
Ms. Good, if you get arrested again for anything else, or if you test positive for illegal drugs or alcoholic beverages, or if you violate the DFACS parenting plan, your bond will be revoked and amended to a 5,500 surety bond or cash bond, depending on how it goes. Thank you. Who do we have, please?
We have position number 1, Mr. Chen, position number 1.
This is Mr. Chi Chen, accused of DUI, less safe, and failure to signal a lane change or turn in case number 22 CR 001290E. All right. Representing Mr. Chen, first of all, do you speak English, sir? I don't mean to be rude. I know, I'm so sorry. The alarm system goes off now and then in jail. Mr. Friedman, do you represent Mr. Chen?
I do. Good morning or afternoon, Your Honor. And yes, Mr. Chen does speak English, Your Honor. He is a U.S. citizen.
All right, thank you. And so Mr. Chen has been advised of his right to remain silent, and his attorney is Aaron Friedman. I understand that this is a first arrest, if I'm not mistaken. Would you confirm?
It is, Your Honor.
All right. Okay, so Ms. Mitchell, what are you recommending in terms of bond?
Your Honor, we're recommending a $2,500 surety bond, $2,000 as to count 1 and $500 as to count 2, and no alcohol, drugs, and weapons. Your Honor, this is a DUI case where the defendant was driving in the left turn only lane and ended up cutting off the officer, forcing the officer to brake. When the officer approached him, there was an odor of alcohol coming from inside the car, and he admitted to the officer he had 1, 2, 3 beers that night. So that's going to be the basis of our recommendation, Your Honor.
All right. Mr. Friedman?
Yes, Your Honor. We're respectfully requesting a signature bond. He's been in custody for 24 hours, Your Honor. If my recollection may be a little over at this point, there was no bond set through pretrial at the jail judge through the officer, I'm assuming because he allegedly cut off the officer. There was no bond set. He has been in custody. We're respectfully requesting a signature bond in this case, Your Honor.
The bond should have been set at the electronic bond stage. I'm not certain why it wasn't, but in the
I don't
meantime,
either.
on the DUI, it's going to be a $1,000 surety bond. On the failure to signal a lane change or turn, that's going to be a $1,000 signature bond through pretrial. His complete bond will be a $2,000 split bond. He will report to pretrial once a month, and he is not to consume any alcoholic beverages or illegal drugs. He will be subject to random screens. Will he be able to make bond, Mr. Friedman?
Absolutely, Your Honor.
All right, then he's required to make sure that we have his current address. I have a Meadow Lane, Meadow Crest, something like that. Is that your current address?
Yes.
All right, you will get notice as to when to appear in court. Presently, because a portion of it is a surety bond, we have a court date of March 24th, but I think I'm going to just further notice this for arraignment.
Thank you, Judge. So it will not be a March 24th date. It will be a further notice date, correct?
It'll be a further notice for arraignment if you can assure me that your client will make bond.
Absolutely. He will
All right.
make bond, Judge.
And he'll report to pretrial once a month and do not consume any alcoholic beverages or illegal drugs. He will be subject to random screens. If he fails to screen, he could be rearrested.
Understood, Your Honor.
All right. Thank you, Mr. Friedman.
Thank you. That concludes my business with this honorable court. May I please be excused?
Appreciate that. Yes, thank you.
Thank you, Your
All
Honor.
right. Thank you. Courtroom 2, next case, please.
Mr. Daniel Ward. We don't have the positions.
Position 10 and 11.
Yes, sir. I think that's Mr. Segura's cases. All right. Mr. Daniel Ward is got two separate cases, one of which, first one, position 10, is 22 CR 001-297C, accused of simple assault from a March 7, 2022 incident. The second case is 22 CR 001-299C, accused of criminal trespass and damage to property and terroristic threats, a misdemeanor, from a March 9, 2022 incident. Mr. Ward, you've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod. Mr. Toussaint, are you back, sir? All right, Mr. Toussaint, pre-trial? All right. Mr. Toussaint, I'm not sure, but Mr. Segura, if you'd like to proceed. Oh, there we go. We have positions 10 and 11. Mr. Daniel Ward, any priors, please?
6 total. 2017 probation violation, 2 counts of trespass, 2016 shoplifting dismissed, 2016 burglary first degree transferred to state court, 2015 unlawful participation in criminal street gang activity not presented to grand jury, 2015 burglary first degree, 2 counts. It was reduced to trespass convictions.
All right, thank you. Mr. Segura, what are you recommending for bond in both these cases?
In both cases, we are recommending a total of a $5,000 surety bond, $3,000 for the battery, which is for the first case, and $1,000 each for the 2 other counts. We're also asking for no alcohol, drugs, and weapons, 1-day anger awareness, and a stay away for the incident location at 2591 Etheridge Drive, Atlanta, and no further contact with Brittany Jackson, spelled BRITTANY, Jackson common spelling. Since the victim is both the same in both cases, we're doing this at the same time. The reason for our recommendation is mostly because on the first one, which was the assault, Brittany Jackson was dragged by the defendant in a stale case, and this was on March 7th. But we also but the victim actually contacted us in the morning, and we have more information about how this whole incident essentially occurred. It's mostly related to the second one. It was on March 1st, Ms. Jackson asked the defendant to look after her daughter in their own apartment. And at that point, Ms. Jackson stepped away for a few minutes. And when she came back to her apartment, she found the defendant in her daughter's room, and when quickly asked, he left quickly without his jacket and did not respond to any of her questions. Now, on the date of incident, which was the 7th, we saw the attack. And later on, we noticed that the victim, Brittany Jackson, ended up talking to the defendant about why he was in the daughter's room at that time, but she did not respond. Later on, at the 9th, he noticed that Ms. Jackson was quickly walking out of the apartment when she saw the defendant. And the defendant was initially upset because Ms. Jackson called the police on him for the assault case on the 7th. And this date, on the 9th, she quickly ran away from him. And the defendant yelled at Ms. Jackson and said, "I'm going to beat your ass." When Ms. Jackson got into her house, the defendant went after her. And Ms. Jackson stated that the defendant kept yelling for her to open the door so he could, quote, slap the SHIT out of her. Ms. Jackson refused to open it, which angered the defendant more often, and ended up in the defendant breaking the window and then go to open it so he could snap him. Because he noticed that the victim said that the victim and the defendant are actually acquaintances, and the defendants actually live in the area. They just come over to visit a different friend in a different apartment in the same building. And the victim stated that during this whole time of the property injury, in which the window was smashed, the daughter was inside the house, and now both Ms. Jackson and her daughter are afraid of this defendant, and they're afraid that the defendant will actually come back to her apartment to harass her. And we actually got to notice that victim's actually on Zoom, and she could provide more info if needed. Thank you.
Thank you. Is Ms. Brittany Jackson on this conference call, on this Zoom conference, and would you like to be addressed? You don't have to address the court if you don't want to, but I'm giving you this opportunity. Ms. McLeod, if you could please.
Yes, Your Honor. My client denies that that was what occurred. He has known Brittany for a long time. She's friends with him and his brother. And what happened was that she was really beating her son very badly in the presence of my client and some others. And she accused my client of recording her beating her son. So she was upset with him because she felt like he had recorded this incident. So she got upset with him. And they were arguing. Then the next day, apparently they ran into each other and they were arguing again. And that was when Brittany accused my client of molesting her daughter, which he was very, very upset about that, because it was an unfounded allegation. He said, he would never do something like that. And he was upset, and she pushed him and he pushed her back. And that was how the fight started. She also has a history, Your Honor, of assaulting people. And based on what my client says, she was beating her own child and was annoyed because she thought she would have gotten reported by my client as he had recorded what she had done. My client does not have any significant criminal history based on what pretrial just said. Right now, he doesn't really have a job right now. He's looking for a job, Your Honor. He's not in a situation to pay bond. And based on his record, I think he's a good candidate for a signature bond. He doesn't live with this person. They've never been in a relationship. So there is really no reason for them to interact. He's happy with a stay away provision in any bond that the court gives him. But it would be a hardship for him, Your Honor, to have to pay bond because he doesn't really have any money. He hasn't been working for a little while. He's looking for a job.
The simple assault charge is going to be a $2,500 signature bond for pretrial services. And on the second case, the criminal trespass causing damage and terroristic threats, that's going to be $750 each for a total of a $1,500 surety bond. He's got a total of 2, 3, 4. It's a $4,000 split bond. So he's going to have to pay for the bond on the second case, but on the first case, it will be a signature bond for pretrial. Once he makes bond, he will be reporting to pretrial once a week. At all times, he's to stay 200 yards away from 2591 Etheridge Drive in Atlanta, Georgia, have no further contact with Brittany Jackson and her minor child, and no illegal drugs, no alcohol, and no weapons. Next court date is March 24th. If he does make bond, then he will be given a separate court date, and that will be mailed to his current address. So he'll need to make sure that we have his current address at all times. Thank you.
Thank you, Anna.
What was the bond amount for criminal trespass and damage to property? The amount?
$750 each, surety bond.
Thank you. Next, we have position 5, Mr. Jones.
We have State versus Courtney Jones, case number 22 CR 0012931. Mr. Jones has been accused of battery, domestic violence, and third degree from a March 9, 2022 incident. Mr. Jones, you've been advised of your right to remain silent, and your attorney is going to be Ms. Wanda Gant. Mr. Tucson, any priors on Mr. Jones?
I think it was first arrest. Hold on. First arrest is what I heard.
For Courtney Jones,
Yeah, you got something else?
I have 25 cycles.
For
Well,
Courtney
that's a
Jones?
big gap.
Yeah, it is.
Courtney.
Well,
We have a Courtney Jones, date of birth September 16, 1988.
that's what I have on my history.
Okay, hold on.
I
Let me just.
have a birth date of September 16th, 1988.
That's what we have.
I thought I heard 1998 as a birth date.
No, I said 1988.
Okay, thank you, Yana.
88. Let me see, double check this GCIC, make sure we have the right person. This one. Okay, the GCIC I have is for somebody born in 1983, so
Okay,
that must be the wrong person.
right, we're gonna assume this is his first arrest, and Mr. Mitchell, what's your recommendation?
Okay,
And
our
I've read-
recommendation,
I've read the warrant, so I don't need to go into the details of the allegation.
okay, Your Honor, our recommendation is okay, it might change a little bit. Well, it was based off the 25 cycles of the wrong person. So with that in mind, our recommendation as to count one is going to be a $3,000 surety bond. And as to count two will be a $1,500 surety bond, totaling $4,500 surety bond. No further contact with Miss Brittany Jones, and a stay away from their address, 2265 Perry Boulevard, Atlanta, Georgia. 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, our victim advocate had an opportunity to speak with Ms. Jones, and Ms. Jones stated that she doesn't want the defendant to have contact with her or her sons, and that they've had prior violent incidents that involve the police. She also wants a one-time law enforcement officer escort for the defendant to retrieve his belongings. Nothing further, Your Honor.
Ms. Gant?
Right, thank you, Your Honor. Mr. Courtney Jones is 33 years old. He in fact also denies any prior arrest. He has been in the Atlanta area all of his life. He is proud father of 3 children, ages 13, 12, and 5. He has been married to Ms. Brittany Jones for 4 years, and they've been together since high school. He also has other family in the Atlanta area, including his brothers and his mom. Your Honor, we are unopposed to the stay away at 1925 Waycrest, as I was able to speak to Ms. Jones, and she states that she does not want any contact with Mr. Courtney Jones. Mr. Jones completed high school. He is a certified forklift operator, and he's currently employed at Amazon as a forklift operator. In light of my client's negative prior history, I am requesting a signature bond. We are again unopposed to the no further contact order. We again would request that one-time law enforcement escort to retrieve his belongings from the marital home, and also third-party transfer visitation with the children. Thank you.
And Your Honor, I'd like to correct for the record, the address. As Ms. Gant stated, it's the 1925 Waycrest Drive address.
Yeah, that's what I've got. Okay, thank you. On the battery offense, it's going to be 2,500. On the cruelty matter, it's going to be 1,000. Total bond is set at 3,500, which is a surety bond. I'm basing this based on the egregiousness of the allegations set forth and the fact that there were multiple minors involved. The bond is set at 3,500 surety bond. Next court date is March 24, 2022.
Your Honor. Your
Yes.
Honor, if I may interrupt, I do apologize. Mr. Jones denies these allegations. The warrant also reads that he denied the allegations at the time of his arrest. He states that he was struck first and was merely acting in self-defense.
The warrant can be read in many ways, Ms. Gann. And I am read the warrant. I've looked at the pleadings of whatever's been provided. And I am going with a $3,500 surety bond. Next court date is March 24, 2022. He's to have no contact with Brittany Jones, no contact with the minor sons until further order of the court. If he seeks to have a contact with the minor children in the interim, they may go to Superior Court and file a petition through a divorce or a separation action in order to establish visitation and custody. He is not to return to the Waycrest location, which is 1925 Waycrest Drive in Southwest Atlanta. And he may return one time only with a police officer in order to retrieve his belongings. And that visit cannot exceed 2 hours. No illegal drugs, no alcohol, no weapons. And while he's, once he makes bond, well, yeah, this is a surety bond, so I'm not going to impose any anger awareness program at the present time. All right, thank you very much.
Position 9, Mr. Spell.
This is Daryl Spell, accused of battery, domestic violence in case number 22 CR 0012988. And Mr. Spell, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. This is an incident from February 27, 2021. Any prize, Mr. Tucson?
14 total. He went to felony earlier, got a $5,000 good bond for that charge. He's on probation for a CWAC charge. Also on probation, criminal street gang activity, possession of heroin with intent, possession of cocaine with intent, possession of meth and marijuana with intent.
That's good. Thank you. Mr. Segura?
The state is recommending a $4,000 surety bond, no alcohol, drugs, and weapons, 1-day anger awareness, and no further contact with the victim, Cheon D. Doe. Cheon D spelled CHEADEE, Doe, common spelling. Allegations are based on the facts, and also because of the unique relationship the victim has with the defendant, namely that they both share the same child. So we're definitely concerned that because of that relationship, she might be more likely to return to him, and that types of violence could rise again. And the victim, when spoken to audio, did state that this isn't the first time the defendant has been violent with her, and as thus, we are concerned that violence will rise again. Thank you, Your Honor.
And the location is 267 Marietta Street. Is that the location from where he's to not return? What's the situation with location?
In this case, this is the incident location, which from our facts, Cheon D. Doe was initially invited to go to this location, and which is not a home. It's a suite, a hotel, or a different girlfriend was, other defendant was there who attacked her. And so it's not her home.
Okay. And they don't live together as far as you know?
As far as we know, they do not live together.
All right.
They just have one child together.
All right, thank you. Ms. Kim?
Yes, Your Honor. Mr. Spell is 31 years old, and he has been here in Georgia for 12 years. He has his family here, his daughters here, his son and auntie, uncle. Actually, right now, he lives at 777 Memorial Drive with his uncle. So he does not live with the complaining witness. And he has a job as a phone repairing person. So he has been doing that for the last 4 years. And yet at this point, he does not have a whole lot of assets because he has served in DeKalb County for the last 4 months because of the probation violation that Mr. Tucson talked about. He had to pay for that. He had to serve and incarcerated in DeKalb County, and he was directly transported from there to here. So we would like to request for signature bond on this, since there is already $5,000 bond for the felony case. And yet, if Your Honor does not believe that he is entitled to get a signature bond, we would like to request for the bond amount no more than $2,000, Your Honor.
Bond is set at $2,500. It is a surety bond. No contact with Cheon D. Doe.
Your Honor.
Oh, there she is, Ms. Doe. Yes, I didn't realize you were here. Yeah, go ahead.
Well, first, thank you for giving me the opportunity to speak. I will say that this incident happened on last year in February. When the incident was reported, the detective did inform me to not that we not have any sort of contact. Within those 6 months, around that time in July, our son's birthday, his name is Nyrel. We have not had contact until, of course, for him to say happy birthday to his son. Within those 6 months, that gave us time to refresh. And what I mean by that is we are not in a relationship. However, I do believe that we are doing a great job prior to his incarceration from this incident. To his previous incident from DeKalb County. We have been doing great as far as communicating. Darrell is a great father. Unfortunately, that situation happened and it is out of our control. If you would have asked me as far as my opinion on a year ago, it would have been based off of emotion and not reason. Within the year, my life has gotten better, and I have grown as a woman. So I am speaking on his behalf to say that, for one, Darrell, I do forgive you. Judge, I am asking that you at least grant access that we be able to continue, because before he was incarcerated, we were, like I say, from his birthday, not our son's birthday, July, we have been meeting in public places for him to be able to see his son, whether if it's through dinner or whatever. He has not called me out of my name. He has not disrespected me. If we feel that we are coming to a disagreement, we may disconnect the phone. Later that day, we talk about it. And that has been my goal for these past 3 years. And we are doing a great job at it. As you can, family and friends are actually on the call list right now. So I appreciate if you guys just comment in the chat to vouch for. My mother is present as well, just to show that there has been growth on both ends as far as when it comes to communication. But thank you so much.
Ms. D, or Ms. Doe, rather. This incident occurred, yes, you're absolutely right. It occurred last February, a year ago. And the warrant was issued soon thereafter. When did Mr. Spell turn himself in on the warrant?
To my knowledge, I'm not sure, because like I said, we haven't had communication, but I don't believe he turned himself in. That's why he's here now. That's why we're here
He's
now.
here because he has a felony case. That's how the warrant got executed. So that's the first question I have. Second question is, I know, but you said you've had contact with him since then.
Correct. So from when the incident happened in July, those 6 month time frame. So from February to July of my birthday, July 14th, we were not in communication. However,
since February of last year to the present.
Correct.
Has he surrendered himself for this particular outstanding case?
Not to my knowledge. I never asked about it. I never received a call even from our detectives to even give me an update of what occurred. Honestly, this was my first situation, so I never even knew it. To my knowledge, I responded to the detective and said,
okay.
I
understand, Ms. Doe, but I'm going to let the legal process go through. Just like you said, you are not aware of the process. This is a very serious charge. The allegations of the warrant are very egregious.
Okay. Is he
considering his criminal record history? The bond is going to be set at $2,500 surety bond. He is to have no further contact with you, Ms. Doe.
What about our?
And he is going to go to Superior Court and file a legitimation action. If your son lives in DeKalb, he will file a legitimation action to establish visitation and custody and contact.
Okay.
As well as any other matters. No illegal drugs, no alcohol, no weapons, and no firearms. His next court date is March 24th. Thank you.
Thank you, Your Honor.
Mr. Green, position 3.
Okay, Mr. Segura, are you good right now? I'm trying to get to all your cases, but let's see.
Position 3 should be mine. So
Mine are 7 and 8.
7 and 8 are left?
Yeah.
Okay. Francois, do you have Heather Rue and Marquette Scott?
I have Mr. Scott. Heather Ruth, that's gonna be, yeah, she went to Grady. She had a
Position 7.
She just got sent to Grady, so she's gonna be a medical reset.
Position 7 is going to be a Grady reset to March 11. And let me address Mr. Scott, please.
All right, you guys switch seats.
So I will take you up very shortly. Let me address Mr. Scott. All right, sir, Mr. Narket Andrew Scott is accused of battery, domestic violence, case number 22 0012968 from a March 9, 2022 incident. Mr. Scott, you've been advised of your right to remain silent, and your attorney is going to be Ms. Maureen McLeod. Mr. Tucson, any priors on Mr. Scott?
11 total. Last arrest was June 2020, simple battery, family violence. Got an open case in Paulding County, 2 counts of simple battery, hindering person from making emergency call. Looks like he's on either probation or parole for armed robbery in Baton Rouge.
That's the one that's going to end in August of this year?
Yes.
Thank you. Mr. Segura, what's your recommendation for this case?
The state is recommending a $3,000 surety bond, no alcohol, drugs, and weapons, 1-day anger awareness, a stay away from 311 Scott Street South, apartment 151, Atlanta. No further contact with Ayanta Russell, Ayanta spelled Ayanta, Russell spelled Roussell, and a one-time law enforcement escort to retrieve his belongings. Allegations are based on the facts, as well as mostly to the nature in which the defendant and Ms. Russell have, namely that they used to be boyfriend and girlfriend and have been living together for the past 2 years. We actually got in contact with the victim this morning, and she said that she does not want to have any further contact with him, and this is not the first time that the defendant has been violent, but it is the first time that police were involved. And Ms. Russell noted that she did not want the defendant to return back to his residence. We believe mostly because the violent nature of his acts that our bond recommendation is justified. And I believe Ms. Russell is actually on Zoom. Thank you.
Ms. Russell, Ayante Russell, if you want to address the court, you could unmute and start your video. Otherwise, okay. Yes. Ziante, we do not have video or audio from your screen. All right, Ms. McLeod,
Yes, Your Honor. Your Honor, my client just recently lost his job, he tells me. So he doesn't really have any money. He's trying to find another job, but it has been difficult for him, of course, because of his record. We would ask the court to consider lowering his bond to as low an amount as possible, just to allow him to get out. I understand that based on his record, the court is not inclined to give him a signature bond, but he really is not in a position to pay any significant amount of money towards his bond, Your Honor. So we would ask that the court consider lowering the bond as it now stands. He is not opposed to the stay away condition that the court wants to impose.
All right. Bonds can be set at $1,500. It is a surety bond. No contact with Ayante Russell to stay away from the home where this incident occurred, and no illegal drugs, no alcoholic beverages, no weapons, and no firearms. His next court date is going to be March 24th.
Thank you, Your Honor.
Thank you. Ms. Ayante?
Your Honor, this concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
Thank you.
Mr. Segura, did you have any other cases?
That's all for today.
All right, thank you. Courtroom 2, who do we have, please? Position 3, Anthony Green.
Yes, it is, Judge.
All right. Mr. Green is accused of theft by shoplifting from a Walmart back on February 10th, 2022, in case 22 CR 001-291J. Mr. Green, you've been advised of your right to remain silent, and your attorney is Ms. Wanda Gant. Mr. Tucson, if you could recite just his theft by shoplifting convictions, that would suffice.
2022, 2016, 2015, and 2 from 2013.
Is that his Georgia history? Because I have this is his first arrest in Georgia.
Anthony Green?
Hold on.
Maybe I'm
Yeah.
wrong. Hold on. Nah.
It's okay.
What date of birth do you have?
Let me pull that GCIC up. 1 moment.
Oh, no. You can look at the booking sheet and tell all these aliases. Nah, yours incorrect.
Yeah, we're on my end. I'm just showing a Florida history. I don't even have a Georgia one. So, okay. Can you say that one more time?
I got Florida too. The convictions,
Yes. please.
2022, because he's on probation in the cab for shoplifting and obstruction.
Okay.
I got 2 from 2013, 1 from 2015, 1 from 2016.
Okay. So, Your Honor, the state's gonna adjust its bond recommendation again, and we're gonna recommend a $2,000 surety bond on this case to stay away from that Walmart, being that he was also issued a criminal trespass warning that day of the incident, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Yeah.
Thank you, Your Honor. Mr. Green is 64 years old. He has been in the Atlanta area for 34 years. He has 2 children, ages 30 and 40. He also is the primary caretaker of his 4 grandkids. We are unopposed to the stay away at 970 Mansell Road. Mr. Green completed the 11th grade. He has been disabled for the past 18 years. Therefore, he has very little means to pay anything toward bond. He has some medical conditions which are complicating his stay while he's incarcerated. He states that he is very cold. He has a history of anemia. He has also been unable to get medications for his bleeding ulcers and for insomnia. I am requesting a signature bond on his behalf. He disputes the allegations, and if Your Honor determines that he is ineligible for a signature bond, then a bond of no more than $500. Thank you.
Bond is set at $1,500, the surety bond, to stay away from the Walmart on Mansell Road. Thank you. Next court date is March 24th. Anyone else?
We're completed here. Important
All
to.
right. Thank you. Do we have something at Union City?
Yeah. Yes.
Okay, I'll wait for Deputy Milton to appear. Meanwhile, we'll just go over the calendar. Thank you, Francois.
All right. Thank you. Have a good one.
You too. Position 1, Mr. Chen was a $2,000 split bond, and that's going to be further notice for arraignment. Position 2, Rashida Dennis. I hope she's at first appearance felony to address those charges.
Hey,
Position-
Judge, I talked to Tracy. She said those are misdemeanor charges.
The cruelty is a misdemeanor.
If you read the warrant, it's actually cruelty in the 3rd and battery from 2016, right?
Yes.
Yeah, it's cruelty in the 3rd.
All right. Can we have? All right. Ms. Mitchell or Mr. Hopkins, if you're present.
Yeah, I'm present, Your Honor.
All right. This is regarding that Ms. Rashida Dennis.
Yes.
Okay, those 2016 charges, do you concur that they're misdemeanor charges? Because I couldn't read the rest of the.
I can't read the warrants and all, Your Honor. They already have a DA number, so whenever they have a
I'll
DA
read
number,
it.
we can't get access to them.
I'll read it. Hold on.
While we're waiting on that, I'm just going to move on. Anthony Green, position 3 is a $1,500 surety bond, reset date March 24th. Position 4 is a $5,500 signature bond through pre-trial. Further notice. Position 5 is a 3,500 surety bond, reset date March 24. Position 6, Quinetta Jones. Anybody know what's going on?
Attorney J. Kim, she waived her appearance.
Yes, Your Honor. She actually, we submitted the waiver of appearance and we are ready to go to talk about this. Shall we do now?
Yeah, sure. So position 3, position 6, excuse me. All right. Let me just ask, who is the, Ms. Mitchell, what's your bond recommendation? I really don't need her GCIC, I have it.
Gotcha. Our recommendation is going to be a $3,000 surety bond. So it'll be 1,500 as to count 1, 1,000 as to count 2, and 500 as to count 3. A stay away from the MARTA 5-point station and no alcohol, drugs, and weapons.
Ms. Kim?
Yes, she has been here in Georgia for 27 years and she does not have any family members. She actually lives with SSI disability checks. So she does not have any means to pay for surety bond at this point. She's living with her boyfriend, and she does have some health issues. So we would like to request for signature bond, but if your honor does not think signature bond is qualifiable, we would like to request for bond no more than $1,000, your honor. Thank you.
On the simple battery, it's going to be 500, and that's going to be a surety bond. And positions 2 and 3 are going to be 500 signature bond through the jail. Next court date is March 24. It's a $1,500 split bond. Stay away from all MARTA property, all of them.
Yes, your honor. Thank you.
The next court date is March 24. This is for position 6. Position 7 is a Grady reset to March 11. Position 8 is a 1,500 surety bond, March 24. Position 9 is a 2,500 surety bond, March 24. Position 10 is a 2,500 signature bond through pre-trial. And position 11 is a 1,500 surety bond. A reset date for both cases is March 24. All right, Mr. Tucson, going back to Rashida Dennis.
All right, so the date of the one is March 28th, 2016.
Right.
The battery warrant says caused physical harm to her mother, Nancy Dennis, by scratching and striking with open hand and closed fist and biting. The cruelty says cruelty to children, allowed to witness felony/battery/family violence, 3rd degree misdemeanor. Primary aggressor had knowledge that a child under the age of 18 was present, sees or hears the act of the accused, which was scratching, striking, and biting her mother. That's it.
Do we have a case number?
I don't see no case number. I just got the warrant number. That's it. And the warrant.
And this is a DA case.
Yeah. And
I've got the case number, Judge.
What is it?
It's 22 DA 0.
I'm sorry, Mr. Hopkins, you then.
One second, I'm trying to, let me,
Is it 2272?
that's correct, Your Honor, 2272, 02272, yes.
All right, now the problem is if it's a DA case, I'm assuming that's unless that's a new acronym for the Solicitor General's office.
It is not.
Okay, so this is a Superior Court matter, and I understand what Tracy had to say, but it is a Superior Court case. I cannot issue a bond. I cannot even issue an order telling her to jump and run unless this case comes back to the Solicitor General's office.
And that's the point that I have, Your Honor, is, you know, with the DA number, we can't accuse it. We can't touch anything. We can't look at anything. And so, you know, it was showing as a DA case. So.
Okay. either one of you can reach out to the non-complex magistrate judge. I don't know who it is. I don't know if Judge Forsky or Judge. I have no idea who all the names now, but if y'all can reach out to her for the Miss Kim, do you represent? No, that was Miss McLeod, right? Yeah, she will have to reach out. I cannot touch this case unless I have jurisdiction as a state court matter.
Okay, Your Honor.
Okay. I'm not going to reset it again, but Mr. Hopkins, can you reach out to that to the district attorney's office and see if they're keeping that case, or is it something they want to send to you all?
What I can do is, Your Honor, I emailed Sierra Bickerstaff in our office and advised her that, you know, currently it's got a DA number that they'll need to change that so that we could accuse it and handle it. So hopefully they'll go ahead and they'll change it over so that that can be done.
Okay, and then you have the other problem that apparently she was a minor at the time of the incident.
There's that. There's the fact that it's a 2016 case. I mean, you know, 6 years old and a minor, you know, those are obviously concerns we would have. But again, like without being able to actually get in and take a look at the case and find out what's going on with all of it, I really can't make comment at this time whether, you know, what the delay was and why it was sent to us versus somewhere else.
All right, Ms. Kim, if you can reach out to your office also to see who handles the felony matters, those particular charges should be dismissed.
Your Honor.
Based on everything I've heard.
Your Honor.
Yes.
How you doing,
yes.
Officer Norris? How you doing? Ms. Dennis already took her file to records, and apparently it was a mix-up, so they cleared her. She's going to be released, so she doesn't have to come to court.
Hallelujah! I'm going to buy you a Snickers bar.
Yeah, and I'm just sitting, like, I've had message, like this morning we started out and I took a look at it and I was just like, look, like it's got a DA number. Like, I don't know why she's back with us. I can't do anything on it.
Exactly.
Okay.
Yeah.
I just didn't want her to sit again, so I just went above and beyond. That's all.
You're the best.
And we truly appreciate it. The hero of the moment. Okay.
Thank you.
Thank you.
All right.
Everyone, hail to Officer Norris.
All right.
All right, folks. Y'all have a good one.
Have a
I
good
like
one.
to end this on a good note. So thank you.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.
Thank you.